have to be. So which employers are covered? Both of the acts, the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Act, take effect on April 1st, 2020, and they will sunset on December 31st, 2020. So they're only in effect from now, effectively through the end of the year. You are voluntarily allowed to comply as of Friday, March 2nd, pursuant to per the IRS. And in effect, what that means is that if you choose to provide this leave, you will be able to get the tax credits as of Friday, March 2nd. But from the perspective of the Department of Labor, when you actually have to comply and start providing the leave, it is April 1st. And and we'll talk about why you might have an incentive to do it one way or the other during the presentation. The two acts apply to private employers that have fewer than 500 employees. And they also apply to government entities. But this presentation is focused on private entities, and the limit of 500 is, the way you reach that is every employee counts as one, whether they're regularly scheduled to work 1 hour or regularly scheduled to work full time. There are some nuanced issues with counting the number of employees, which is beyond the scope of the presentation. If you are close to that, then that's an issue that we'll need to address individually with each of you. Which employees are covered? It applies to all of your employees for the sick leave provision. And for the EFMLEA extension, emergency leave, it applies to anyone who's been employed for 30 days. And what that means is if they've been on your payroll for 30 days, then they're an employee for 30 days. There are some exceptions for an employer who has employees who are healthcare providers. They can opt out of it. And the DOL is also expected to issue regulations which will allow an exemption for small businesses with fewer than 50 employees from participating, from complying with the Act. We expect those regulations to be issued in April. And for now, if you think that applies to you, you want to be documenting why, you want to start documenting why the imposition of these requirements would jeopardize the viability of your business as a going concern. I think that is going to have limited practical implication because of the way that the reimbursements and the credits and the refunds of the costs of complying, at least of the cost of providing the benefit, are passed on to the government. So, reasons for leave. Emergency paid sick time is the leave that starts at the beginning of somebody's leave requirement. It can be taken if the employee is unable to work or telecommute due to the need for leave because of the 6 reasons. And the first 3 listed here are basically if the employee is subject to a federal, state, or local quarantine or isolation order, or if they've been advised by their healthcare provider to self-quarantine due to concerns about them actually having COVID-19, or if they're experiencing symptoms of COVID-19 and they're seeking a medical diagnosis. So a couple of things to point out about this. Whether a general shelter-in-place order, which is in place in some jurisdictions and may well be in place in many jurisdictions, whether that would qualify as an isolation order. It's unclear. I think it probably hopefully we'll get some guidance from the Department of Labor, because it's one argument is that it's out of character with the rest of the provisions here, where we're effectively thinking about an individual human being who we suspect has COVID-19 and therefore is quarantining themselves. But a general shelter in place is probably an isolation order, even though it will always be subject to, you're allowed to go to the grocery store to get food and to the pharmacy to get medicines. So then the other reasons that you can take, that an employee is entitled to paid sick leave, emergency paid sick leave, is if they're caring for somebody who's subject to one of those quarantine or isolation orders, or self quarantine orders, or, and this is probably the most practical implication order requirement so far, at least up till now, is if the employee is caring for a son or daughter, if the school or place of care of the son or daughter has been closed, or the childcare place is unavailable due to COVID-19 precautions. So the key point here is that the precautions, the school closures due to precautions, is quite broad. My read on it is that it's broader than simply the governor ordering schools closed. So even if the governor allowed schools to open, but a particular school said, no, we're concerned about COVID-19, so we're staying closed for precautions, that I think would qualify the affected individuals for this kind of leave. And then other substantially similar conditions, who knows what that means. Maybe if HHS and IRS and DOL provide us with additional information, then we'll have additional reasons for the leave. So reasons for the leave, it can only be taken because the employee is unable to work. Sorry. Now I'm moving on to the emergency family leave, and we'll talk how these two leaves coordinate with each other in just a minute. So the reasons that you can take emergency family leave is much narrower. It's only one of those provisions above, and it's slightly differently stated. You're only able to take this leave if you're caring for a son or daughter under 18, if the school, place or business, place of care has been closed, or the childcare provider is unavailable. And here's where the language that is used in the EFMLEA is different than it is for the emergency paid sick leave. It says, due to an emergency, if it's closed, due to an emergency with respect to COVID-19 declared by a federal, state, or local authority. And so I think there's the reason, maybe I'm assuming things, but a lot of the language that is used in the statute to refer to the two kinds of leave is parallel, and this is distinctly not parallel. And I think this means that for the family leave, it'll be narrower. The circumstance I gave, where if there is no closure due to an emergency declared by the federal, state, or local authorities, and the school voluntarily closes, that this would not apply. That's my current take on the law, but it may well be that the DOL tells us otherwise. How much leave do you need to provide? For the emergency paid sick time, full-time employees are entitled to 80 hours of paid sick time, and part-time employees are entitled to a number of hours equal to the number of hours that they work on average over a 2-week period. And so this raises some questions about, well, does full-time have to mean 80 hours a week? What if you define full-time as 35 hours a week and not 80 hours a week? Then it's unclear at this point whether you have to provide 80 hours or 2 times 35. And hopefully we'll get some guidance about that. What impact one of the significant questions I've been getting a fair amount of is what happens if we've reduced our hours before April 1? So some businesses have reduced the hours that people are required to work because of a business slowdown or for other reasons. And so what is the number, now for purposes of the number of hours of sick leave that you have to give, I think probably the right answer is the schedule before you had shutdowns begin. But it's arguable that it may be if you've already had, say, a reduction in force or an across-the-board furlough where you've told everybody's going half-time, for example, maybe the answer would be different. And again, hopefully we will get DOL guidance. Given the purpose of the law, which is to provide sick leave and paid sick time under EFMLEA to affected individuals, I would expect that the DOL would take a broader, and IRS would take a broader view of this. But it's not 100% clear. And for example, which we'll talk about in a minute, if you did a complete layoff where your employees were not working at all, well, you would still need to give them you'd have to make sick time available to them, but they wouldn't be able to use it because they wouldn't be working for other reasons. And we'll talk about that in a minute. So for purposes of the leave you have to give, I think we're going to be probably generous on that, but we need to wait for Department of Labor and IRS to clarify those murky situations where somebody is full-time but not working 80 hours every 2 weeks. What that works out to be, the emergency paid sick time effectively works out to be 2 weeks. So the law is obviously trying to cover the first 2 weeks, say, for the broader reasons, you all can get this 2 weeks of paid leave. For emergency EFMLEA leave, which picks up after that 2 week period has run, it says you get the leave and it's unpaid for the first 10 days. And it's for people entitled to emergency EFMLEA leave, it would run concurrently with those first 2 weeks of paid leave under the Act, paid sick leave. And then you get it for 12 weeks of total. And an employee can elect under EFMLEA to substitute any accrued vacation leave or personal leave or medical or other sick leave during those first 10 days. That would apply to somebody who is not eligible for the emergency paid sick time, but may be eligible, say, for sick leave under a state law, which might say that you get sick leave or personal leave while you're qualified for the emergency EFMLEA leave. Theoretically, you could substitute other leave in. It's highly unlikely that somebody would want to do that, because if they qualify for the emergency EFMLEA leave, which is unpaid for the first 10 days, then I can't imagine a circumstance under which they would not qualify for the paid sick leave. So that probably has no practical implication. The other thing is that employers cannot deny employees who qualify for emergency EFMLEA leave to use their accrued vacation, PTO, and state paid sick leave time during the first 10 days of such leave. So if they decide that's what they want to do, then they need to be permitted to do that. And again, as I said, it's unclear whether this will actually ever apply as a practical matter. So both, how are you required to compensate paid sick time and emergency paid EFMLEA leave? Both of them are based on the employee's regular rate of pay under the Fair Labor Standards Act. So that's a number that you ought to be, most employers will be familiar with calculating. And then multiply that by the number of hours that the employee would otherwise be normally scheduled to work during the time when they took this leave. And that's where we get into a key issue, which we'll talk about in a minute, about what happens if somebody's hours are reduced or they're able to work part-time and not the rest of the time that you would want them to work. The number of hours that the employee would otherwise be normally scheduled to work is probably reduced by any slowdown or office closures, but it's possible that we'll get some guidance. So for example, as I was saying, if you put people on half-time, for example, and they're working from home because there's the nature of the work that they do, they have to stay home, and you've said, okay, half-time, that's all the work that I need from you or can get from you, given that you're working from home, and by the nature of your work, that's all you can do. And then they get their son or daughter home from school because the school are closed. Now the question becomes, well, how many of those half-time hours are they unable to work due to the fact that the school is closed? And you don't compensate them for hours that they wouldn't be able to work if they were on a full-time schedule, because they're not on a full-time schedule. They're on a part-time schedule due to reasons other than a qualifying reason for their leave. So for an employee who schedules that, another issue comes up for people whose schedule varies so much from week to week, so that you can't determine the number of hours that they would have worked if they didn't have that qualifying reason for the leave. And there, the law requires use of averages basically over the six-month period ending on the day they took the leave. Or if they haven't been employed for 6 months, then what was the reasonable expectation of the employee at the time they were hired into that position about how many hours they would work. So there's some discretion and judgment that has to be imposed here, and reasonableness that has to be imposed to determine how many hours they would have been paid had they not taken one of these forms of leave. For the amount, as to the amount of pay that you have to pay for each hour that they take the leave, for the first 3 items of the paid sick leave, which is the first 2 weeks. So those are if you're in quarantine, if you're in isolation, or you're seeking diagnosis for COVID-19, you pay 100% of regular pay, subject to a maximum for each day of $511, or 10 times that in the aggregate over the 10-day period. Then for sick time caring for others who are quarantined or home from school or daycare, it's 2/3 of regular rate of pay, subject to a maximum of 200, and for the sick time, 10 times that, which is $2,000. And then when we move on into emergency family leave, it remains for those who qualify for that, which remember are only people who are home because their kids are unable to work because their kids are home from school or daycare, childcare. It remains 2/3 of their regular rate of pay, subject to a maximum of 200 a day. And now obviously the aggregate becomes 10,000 because you're adding up, there's 50 days worth of family leave potential that they could get. So what are the notice requirements? The law requires every employer to provide notice of these rights, just like you have to under EFMLEA and for minimum wage requirements. You have to keep them posted in the same places you would post those notices, which is all in the places where employees are notice of customarily posted. The DOL has posted notices and other guidance. So this is one of those links I was talking about here. Go to this website. You can download the notices there that they have published. They published today. It's a one-pager. They've also indicated that if you have employees who are remote working, you can email the notice to them, and that's obviously a good idea. You want to do more than is just required by the law. You want to do what makes sense from the perspective of actually getting the notice into the hands of your employees, because there is a lot of benefit to employers as well as employees from this act. Even though it's a hassle to comply with, there are benefits, and being able to pay your employees on the government's dime is kind of a good deal if you can. And so the other thing you want to do, highly recommend you do, is that you provide some forms to your employees, or some method, and it's usually going to be in the form of a actual form that they will fill out, for them to notify you of their need for leave. And we'll talk more about that a little bit below here. The law requires that after the first workday or part of workday that an employee receives emergency paid sick time, then you may require the employee to follow reasonable notice procedures in order to continue receiving such paid sick time. And what I take that to mean is basically the employee gets a freebie. First day that the school is closed, or that the situation arises where they think they need to go to the doctor and get diagnosed, or somebody in their house is ordered to quarantine. For that first day, they get to just deal with that circumstance, but then after that, they need to notify you. And in any case, you could make that even more relaxed. You could allow a week for somebody to notify you of the amount of time that they have taken in the prior week due to one of the qualifying reasons. And I think there are good reasons why you will want to give more than one day to your employees, along with good requirements that they document to you that they actually qualify. And in any case where the emergency family leave is foreseeable, which is when children are home from school or daycare, they have to apply the employer with such notice of leave as is practicable. And so that leaves you with a lot of discretion to say, well, here's the notice that's practical, and it's going to tie into things like your pay period, when you have to submit your payroll. You want to know, ideally, you want to know when you submit your payroll that you've got it right, and that somebody who isn't going to come and claim leave after you've paid them. Maybe you don't mind that. That would create some headache, but maybe you do mind that, and so what's practical will dictate the kind of timelines you put on that. And hopefully we're going to get more DOL guidance on those issues. The bottom line is that you need some processes that will document what your request, the employee's request is, and it's going to mirror those qualifying reasons. You'll notice we'll have some kind of a checkbox system that says I'm claiming leave for this reason, and here's how much I'm claiming and the days I'm claiming, and here's my documentation to support it. And so I think a little bit of effort in the next couple of weeks to get those kind of notices in place, and going back to the beginning point that you select, which we'll talk more about either April 1st or before April 1st. Some of that before you go out and start getting willy-nilly from people, I want this leave, I want that leave, I want this leave. To the extent that you can put a process in place to get the information you need in one shot, I think some work up front will be well worthwhile to accomplish that. So you're going to want to inform your employees of the need, of what they need to do to take leave under the Act, and that's I've essentially already talked about that. So some sequencing issues that might come up before April 1st, or the earlier voluntary compliance date, which is last Friday. You could consider paying out state mandated sick leave, if that's possible under the state mandated sick leave law. So that for people who were off. Now, this might apply to people who are off for reasons way beyond or beyond what the federal law requires. But a lot of businesses have had disruption, people off work, and to the extent that has occurred, you should look at your state sick law. Does it apply, or can I apply it to pay people and reduce the pay people during that period and reduce the future obligations under that paid sick time? Do I have to pay under that sick leave law is another question you ought to be addressing. And then, as of April 1, or the earlier date compliance date that you pick, if you pick an earlier date, if applicable, the emergency sick time, paid sick time comes first. So this is priority over everything else. It gets to go to the front of the line. So you cannot say, if somebody qualifies for the earned paid sick time, you can't say to them, hey, you have to take your local law sick time, or you have to take my vacation time before you get that sick time. You can't make them move that sick leave to the back of the line. And you don't really have an incentive if they qualify. You have no incentive really to do anything other than put it to the front of the line, because the feds are essentially going to reimburse you for the full cost of doing that. So you have every financial incentive to do that. If somebody is off work and they don't qualify for one of the qualifying reasons for earned paid sick leave, or at the end of that 2-week period, if it runs out, then consider whether they are eligible for emergency EFMLEA leave. And this might occur, for example, if somebody qualifies for 2 reasons for sick leave, their kids are home and they get diagnosed with COVID-19, and then after that period, their kids are still home, then they would then qualify for the family medical leave. But even if you qualify under 2 bases for the sick leave, you only get 2 weeks or 80 hours for full time. You only get 2 weeks of that. They don't stack on top of each other. So, for example, if consider full-time employees, we're going to try and pull all of this together here with an example. Consider a full-time employee who's paid $30 an hour. They could work full-time at home, so they have no disruption due to any business circumstance. They could work full-time, but now one of their children is off school due to a school closure, and as a result, they can only work half-time. The rest of the time, they have to take care of their child. And now this will all be gathered. You will get the facts to support this from the notices you provide them and the forms you require them to fill out and the documentation you ask them to provide. Once you conclude that, you will pay the full wages, which is for 20 hours a week. That's for the full wages for the hours they actually work for you. And then you'll pay the other half of the hours, 20 hours at $20 an hour, because that's 2/3 of 30. Because the reason their sick time is half of their full time, and they will use up, as a result, they'll use up in each week, they'll use up 2.5 days of earned paid sick time. So for this particular individual, the 2-week earned sick time period could actually run out for 4 weeks before they run out of that earned paid sick time. And effectively what that means is they're able to take it in at a reduced rate, just like family leave can be taken on an intermittent basis. One of the other issues is, and I'm not going to go into great detail here because this is not something that concerns you today, but it will concern you in the future, is EFMLEA generally has job restoration, job reinstatement rights for employees. They get to come back to the same or a substantially similar position. And those same rules will apply to the emergency family leave, except for employers that have fewer than 25 employees. And for them, you won't have to restore people to their leave if the position that they held when they started out on the leave doesn't exist when they want to come back. Excuse me, sorry. If it doesn't exist when they want to come back due to economic conditions or other changes in operating conditions of the employer that affect employment and that are caused by an emergency with respect to COVID. So if your business is shut, your restaurant, your business is shut, you obviously don't have to restore somebody to a job that doesn't exist. But anticipating that there will be an economic recovery at some point, in order to get that relief from holding the job open, you're going to need to make reasonable efforts to restore them to a position that's either equivalent to the one that they were in when they commenced, or if there is no such thing, then you will need to keep making such efforts for 1 year after the date that their leave ended. So there will be some documentation requirements there and keeping the list of the employees that you need to consider for reinstatement under the Emergency FMLA Act. So some other random notes here. These sort of didn't quite fit in a particular category, but they're things that I think everybody needs to be aware of. Wages that you pay by reason of these acts are not considered wages for purposes of the employer's Medicare tax. So you do not have to withhold Medicare tax on those wages, but they are subject to Medicare and FICA taxes for the employee. And so you will continue to withhold from what you pay employees their share of FICA taxes. Also, another issue, presume you're not limited to paying people who are on this qualifying leave only 2/3 of their regular rate of pay for those who qualify for that level of leave pay. You could presumably pay them more, and then when you pay them more, you could, subject to your paid time off policies providing for it, or the state mandated leave permitting it, you could presumably, in some circumstances, pay them an additional amount to bring them all the way up to 100% of their pay, so that they have no loss of income during the period that they're on this leave. There are, like in regular FMLA law, there are anti-retaliatory provisions. So you don't want to retaliate against people for taking leave, or if they complain that you haven't done it right, you don't want to retaliate against them, and they get all those rights that they get under FMLA for taking FMLA leave. The other thing is, if you get to a certain circumstance where you have somebody out on this leave and you do a reduction in force, you're not or a termination for that reason, you're not required to pay out the unused earned paid sick time or paid FMLA leave upon termination. And the reason for that, well, is the law provides for it, but it also makes sense because if somebody isn't working, they're not, because their employment terminated, then they're not losing income because of their qualifying reason. They're just losing that income because they're not employed. But that obviously relates to the anti-retaliatory provisions. The DL is going to issue some guidelines to assist employers in calculating the amount of paid sick time under the Act. So look for that in the next week, maybe 10 days. And that'll be very helpful. That'll allow you to go back and if you make good faith efforts to comply and you make a mistake in how much you pay or don't, or make a mistake in either paying too much or not paying enough, then you may be able to adjust based on the guidance that we get. Then they're also going to supposed to give us some guidance to ensure that we're consistent in applying the two acts and making them work together. The other thing is that if there are violations of the act for earned paid sick time, it's enforced under the Fair Labor Standards Act, like failure to pay minimum wages and overtime, and the Emergency FMLA Act violations would be enforced under the FMLA provisions, both by Department of Labor. Fortunately, Department of Labor has told us they're not going to do anything to enforce for the first 30 days. I doubt they would have the resources to do that anyway. But they're giving you a non-enforcement for the first 30 days as long as, so mistakes that you make now can be fixed basically. If you make mistakes in good faith in the first 30 days, and it's probably almost certain that if you have the supply, you're probably going to make some mistakes. But as long as you've acted reasonably and in good faith to comply with the Act, and that means that when you identify an error, you remedy it and you make the employee whole as soon as practical. And your violations weren't willful, which is basically the same thing. And the department receives a written commitment from the employer to comply with the Act in the future. They've told us they're going to give us some guidance about what that means. They don't want people sending statements to them now, providing a written commitment to comply with the Act in the future. So hold off on doing that if you get into that circumstance. What if the employee can work remotely from home? How does that affect this whole situation? If they're able to work, then to the extent they're able to work, there can be no loss, there can be no paid sick time because they're able to work. It's only if the circumstance that qualifies for the leave precludes them from working, makes it such that they cannot work. And so back to the example of the employee who can work remotely, kids are home from school. Does that mean they can't work at all? Maybe, maybe not, depending on their circumstance. So what you want to do is, again, this comes back to the documentation you require from your employees. And you want to, counterintuitively, you want to encourage them you want to make it easy for them to tell you that they can't work due to the condition that they have. You don't want to try and restrict their ability to tell you that because it's in everyone's interest, other than the federal government's, who's paying the bill, to have the thing apply. And obviously, I'm not saying you should be untruthful, but you're going to be working reasonably with your employees so that they're fairly compensated and so that they can get everyone's interest is to make this law work and work well. The other issue we have touched on, and the more I look at it and the more I think about it, I'm sure it applies, is intermittent leave. If somebody, I already gave the example, somebody can work half-time at home, but can't work the other half because of the nature of their job, then to the extent we are not able to work that half-time at home because of leave, then they would only get they would only get that amount of time as paid leave. That would be intermittently. Can they get partial pay from the sick leave and partial pay through other approved leave? Yes, if the reason they cannot work full-time is due to a qualifying reason. So this comes back to the example of a full-time employee who could telecommute full-time but can only telecommute half-time due to the need to care for children off from school. What happens down if an employer closes down an entire divisional location and furloughs its employees? So we have this situation, you say you're in non-essential surgery and your practice is shut down and the business is just not operating at all. It appears to me that there is no earned paid sick time payable to your employees during that time, because the reason they're not able to work isn't due to a need for leave. It's due to the fact that the business is closed. Under existing FMLA regulations, this is kind of an interesting thing. Somebody can take that earned FMLA leave. They can get onto earned FMLA leave even if their hours without the leave would be 0. And they remain on that leave, but the days when their hours would be 0 because the business is closed don't count against their leave requirement. And the existing FMLA regulations give a specific example of closing down a plant for Christmas or closing down a plant for a few weeks to retool. People on FMLA leave don't get charged their FMLA leave for that 2-week period, but they remain on FMLA leave and they will remain eligible for all the protections, anti-retaliation and so on. So it appears to me that compensation under the Acts to your qualifying people would be 0 if the business is entirely closed and they would not be working even if they didn't have the sick leave qualifying reason. If an employer needs to lay off or reduce force, which may well happen to a lot of you, what impact will the Acts have on implementing the layoff or RIF? It's the same as if the employees are on any other form of leave, regular FMLA or ADA. Watch out for retaliation. Doesn't mean you can't do what you need to do for your business, but it does mean that these people have an aura of protection around them like other people on FMLA or ADA or other employment-related issues where there is protection against retaliation. What if you've already implemented a furlough before April 1, 2020? Do you need to allow employees to have access to this program? Again, the answer there is not until they would otherwise be back at work, but for the qualifying reason. And again, here, it's possible DOL might be more generous when we get guidance, but that's my best take on the law at this point. Tax credits. We've got a few minutes to talk about the tax credit. This is obviously of great interest to all of you. This is how you're going to get the money back that you spend on these qualifying leave programs. The credit is allowed against the employer's Medicare tax that's paid. That's under the statute. And IRS indicated on Friday, March 20th, that they were going to allow voluntary compliance and voluntary, if you're complying, you'll be able to access the credits as of Friday, March 20th. I think that means as of pay for Friday, March 20th, might mean pay as of Saturday, March 21st. They didn't exactly say. The credit in any event will apply as of April 1st, regardless, because that's the date you have to comply with the leave requirements. You don't get to wait beyond that date. And it equals 100% of the qualified sick leave and qualified family leave wages. And those are defined terms which are slightly different, slightly more generous than the amount of pay that we talked about up above. And we'll talk about that in a minute. The IRS says that their reimbursement procedures will be very quick and easy to obtain. And they're going to give us some guidance that they promised to give us guidance this week about how to do that. But basically what they've said is it's going to be an immediate dollar-for-dollar tax offset against the payment of taxes withheld for federal income, the employee share of FICA, and the employer share of FICA taxes with respect to all of its employees. So each pay period, when you submit your tax payments, you'll be able to take a credit against all of those obligations for the amount of paid sick leave and emergency paid sick leave and emergency family leave, paid family leave that you provided. And if that's not enough, which is probably an unlikely circumstance, but if that's not enough, then you'll be able to get a refund. And the IRS says they'll process those refunds as quickly as possible. So, and the way they do that is they say any excess credit that you're entitled to over, in addition to what you actually owe in terms of those withholding taxes, will be treated as an overpayment. And they're going to allow employers to take immediate advantage by taking that. They're going to put in place a streamlined process where you can submit a claim and get your refund they say within 2 weeks. So you'll be able to get a refund effectively. You'll be claiming your refund each time you submit your taxes, rather than having to wait until the end of the quarter and submitting your 941X to claim your refund. And although that will still be an option for you, and probably what you'll do is you'll square up at the end, depending on at the end of each quarter, to see if you are in fact entitled to a refund. But in the meantime, if your obligations to pay leave are so great that they exceed the actual taxes you're withholding and otherwise transmitting to the government in each pay period, then you will be able to go for a streamlined refund if you need the cash flow and if that makes sense for you. The other thing is any refund, this is now the excess over the credit, is going to be taxable income to the employer. And that makes sense because that's money the employer otherwise would not have received. And so it's going to be includable in the employer's taxable income. So definition of qualified sick leave wages and qualified family law wages means the wages that are normally subject to FICA taxes, which are paid pursuant to the Acts, and that would be up to the maximum amounts required to be paid, the $200 or $510 per day, and the maximums for 10 times that and 50 times that the $200 a day. And but it's further increased. So it's those required wages that you have to pay, plus an amount that is incurred by the employer to provide group health plan coverage as are properly allocable to the qualified sick leave wages for which the credit is allowed. So effectively, you get a pro rata portion of whatever the employer is paying for group health plan coverage that the employer gets back as well. The IRS is likely going to issue guidance on how to allocate. And again, this is the first time. The other link was to the Department of Labor guidance page. This is a link to the page where the IRS will be issuing guidance. So bookmark that page and go check it out there. When the guidance comes out about how to allocate qualified sick leave, the healthcare group health plan expenses to the leave paid, it will be there. So in the absence of guidance, the statute allows you to make a pro rata allocation among your covered employees. In other words, take the total cost for healthcare coverage for the period that you're allocating and divide it by each covered employee. So it's not particular. One employee has family coverage that costs the employer more. Another one has self-only coverage that costs the employer less. You don't have to make the allocation based on the coverage they actually have. You can pro rata allocate it amongst all of them. And then further prorated on the basis of the period of the coverage, which would be a 2-week period or payroll period, relative to the time periods of the leave to which the wages relate. So you're paying your medical coverage on a monthly basis, allocated back to, well, how many days what pay period did this cover, and then what hours, as opposed compared to all of the hours that we paid them, was what percentage of all of the hours that they're expected to work that month effectively was compensated under the Act. Here's an example of how I think that will work. I am not 100% sure of this, but this is what I think. If you've got $25,000 total healthcare premium cost to the employer for April, and let's say you have 50 employees covered in the plan, that would be $500 per employee. So now when we're talking about an individual employee, we're talking about $500. And if we pay employee A for 10 days of sick time in April and they work full time for the other 10 days, then half of that 500 would be allocated to the sick days, and half of the 500 would be allocated to the non-sick days. But what happens if they work on a reduced schedule due to a business reduction? Then you probably take the amount of sick leave that you pay divided by the number of regular work days that they would have worked had they not been off on the sick time. So if the business is shut down and nobody's able to work at all, then there's no paid sick time and there's no credit. The credits apply to self-employed business owners. If you're subject to self-employment tax, and you also get the credit and a refundable credit against your income tax, if they would have been entitled to receive the paid leave if they had been an employee of an employer. The amount of the credit is the number of days they're unable to work for a qualifying reason multiplied by the lesser of those limits, 200 per day, 500 per day, or 67% or 100% of the average daily self-employment income for the taxable year, depending on the qualifying reason for the leave, and is subject to the same 10-day and 50-day maximums. So let's take an example of a tax credit. Let's say the employer paid $5,000 in qualified leave in a pay period and is otherwise required to deposit $8,000 in payroll taxes, including taxes withheld from all of its employees. There would be income tax and payroll taxes and FICA taxes from their employees. The employer could use the entire $5,000 of the $8,000 it owes as a credit, and they will be required only to deposit $3,000 on the next deposit date. If, on the other hand, the employer paid $10,000 in sick wages during that same week, and they were required to deposit $8,000 in taxes, they could use the entire $8,000 of taxes credit, deposit nothing, and file a request for an accelerated credit for the remaining $2,000. So that's basically how those tax credits are going to work. Obviously, this is how the IRS thinks they're going to work. You're going to need to work with your payroll provider to set it up to actually claim the credit, and so talk to your payroll provider. And the good news is that, that you'll be able to, to the extent you comply with the law and are unable if you are unable to do this because your payroll provider isn't set up yet, you will be able to still get the money back at the end of the day, at the end of the quarter. Some related issues to think about, and this is not exhaustive, but it's some issues, is you've got group health plan coverage that has to continue while somebody is on family leave. And those rights would apply to people on emergency family leave as well. If you're paying them, you deduct the employee portion from what you pay them. If you're not paying them, usually you need a policy that, and most policies will say, we either require them to pay or we will front them the cost and we deduct it again from them when they come back to work. If you're doing a RIF and you use measurement and stability periods for the Affordable Care Act coverage, watch out, because when you terminate somebody, when you terminate somebody, the coverage ends. But if you reduce their hours such that they go from, say, your requirement is 30 hours a week to be eligible, and you drop them down to 20, if you're using standard measurement, if you're using measurement and stability periods, maybe you're not allowed to drop them from coverage when their hours go down. So watch out for that. And related to that, consider when COBRA kicks in. Obviously, they don't get COBRA, assuming you're subject to COBRA. They don't get COBRA unless they lose coverage due to a reduction in hours or termination. And so maybe they don't even have a loss of coverage to begin with. And even if they do, talk to your insurance broker about what the insurance companies are doing. They're coming up with some innovative things, delaying, changing the policy about taking people off in recognition of the fact that some people are going to have a reduction in hours, and then who knows, weeks, a month or two from now, that they'll be back to work. And so talk to your broker about what the insurance company is and can do for you on that issue. So we're going to turn to some questions now. And so now go ahead and put your questions into the chat. And I will see if I can answer some of these questions. So here's first question. One question. If we have 32 employees, my thought is that we're exempt from the Act. No, that's not true. You're not exempt from the Act. So it applies all the way down. You may, as I said, be subject to an exception for if you can show that it would cause business. I don't remember the exact word, but destruction of your business effectively. You may be eligible to get exempt pursuant to guidance that's coming out. But like I said, I don't think that's going to be real broad. The next question. Most recent bill removed language about employers required to make available the 80 hours of emergency paid leave in addition to current PTO plans or sick leave. Does this mean that if we already offer at least 80 hours of PTO, we don't have to add an additional 80 hours of sick pay? I don't think so. I think you have to offer the sick pay. Like I said, it comes before anything else, and you cannot require people to take other leave before you use it. And then the related question here is, if we already provide the Arizona 40 hours of sick pay by law, we would only have to offer an additional 40 hours to these employees to make the total available 80 hours. I don't think so. I think you need to, the law says it's not designed to diminish people's rights under other law. And so I don't think you get to double dip when you're paying paid sick time. I don't think you get to double dip against other leave payment obligations like vacation, state sick law, that kind of thing. Next question. We have full, part, and variable hour employees and have had significant business disruption, closures of several departments. We offer generous PTO and have allowed employees who have been impacted to use all of their pay. What happens when they run out of PTO and there is still no work for them? Okay, this is it better to do a furlough, layoff? That's a very particular question. I can't give you a general answer to that. The answer, unfortunately, is it depends. And it's so particular to each employer whether it's best to lay everybody off. Well, if you lay everybody off, they're not your employee. Then when you restart, you've got to rehire them. Do you want to do that? If you furlough people, they're still your employee, and there may be knock-on implications for that under the, well, either way, there's knock-on implications under the WARN Act. You might have to give WARN Act notices. But if you furlough people, then when you bring them back, you're not rehiring them, you're just bringing them back to work. And they will, as employees, they'll get all kinds of other protections. I'm sorry, that's just beyond the scope of this presentation. I can answer those kinds of questions only in a particular. Can employees use earned paid sick time if we don't allow them to come to work due to potentially being exposed to someone with COVID-19? They don't have symptoms, but we don't have test results back yet for the individual that could have been contagious. So this is where you say, we're contagious, or we think we might be contagious, and therefore you don't come to work. I don't think that qualifies, because the employer hasn't put the employee into isolation. You don't have that power. They're not in isolation. They're just not allowed to come into your workplace. So I don't think that circumstance would qualify under the Act. Let's say, next question, if the employer has less than 500 employees, but is a sister company to other companies under a parent company, and that parent company has more than 500 employees, do aggregation rules apply? So this gets into how you determine the number of employees, and the issue is, if you have one EIN in one company that employs people, that is a separate entity, but there are some rules under EFMLEA that say when you have to combine entities together. And I'm going from memory here. They essentially say if they consider things like joint, they consider a bunch of factors, including is there common management, something like common business activities, and common ownership is definitely one of the other things. So again, unfortunately, the answer is it depends. But if you had two entities, one owns 100% of the other one, and they're related to each other, so they have complete common ownership, and they are both effectively, one is a division of the other, I think that counts as one. But think about the purpose of the law here. That would take you potentially out of the Act And so I don't have a hard and fast answer to that. I think I would need to think about it, and we need to look at the particular circumstances to conclude whether it applies. Question: how do we get a copy of the slides? Well, right at the top of the chat, very, very top of the chat, I put a link where you can click on that link and just scroll all the way to the top of the chat box. You'll see a link in there where it's on the ERISA Benefits Law website where you can download the PowerPoint. Does the employer absorb the 1.45% of FICA as well as the workers' compensation that needs to be paid? I believe the answer is yes. What do you do with an employee who is pregnant? If she's due to deliver her baby in the first couple of weeks of April, once she has the baby and is off for 6 weeks and then is ready to return, but she can't find childcare because the daycare she had lined up is still closed, does she now qualify for the emergency family leave? I would think yes, because the employee would be coming back to work and can't come back to work because they can't, because the childcare center that they would use is closed. I think that qualifies, and that would qualify as a qualifying reason for the leave. Has the DOL issued guidance on how to apply for the exemption? As of this morning, and as of what I saw, no. But I can't promise you they haven't done it in the meantime. Have employee notices been posted on dol.gov? They are on the Department of Labor website that I put in the presentation. There are both notices for the emergency paid sick time and for the emergency family leave. Our employers or healthcare providers, do we need to offer? Possibly you may be subject to that exception. And again, that depends entirely on the circumstances of your employer. I can't give a general answer to that because the answer is it depends. And we also don't have much guidance about that. And we may get some guidance from the Department of, I think it's going to be Department of Labor that tells us how that exception works. It's written into the statute, but we're probably going to get some additional guidance. If an employee is currently out on FEMLA, upon return, do they still have opportunity to use the public health emergency leave if they've exhausted their 12 weeks within the past 12 months? Interesting. So somebody's on FEMLA now. For some, presumably you're telling me they're on FEMLA for some reason unrelated, not on emergency FEMLA. Obviously, they're on a pre-existing FEMLA. That's a great question. While they're on FEMLA leave, they're not unable to work for a qualifying reason because they're unable to work because they're on pre-existing FEMLA. This is a wonderful question. I'm sorry, I don't have the answer off the top of my head. I would think, given the purpose of the law, the day they would otherwise come back to work, if they qualify for the emergency paid sick leave, you need to pay it to them. Whether you need to pay it sooner is to me the really interesting question, and I don't know the answer to that. Thanks, Robbie, for posting the link again. And thanks, Heather, for posting the link to the DOL website. And I think those are all of the questions. If you have any addition that I didn't ask, please type your question in now. And I will do my best to answer that. And if you have particular needs for assistance, obviously I'm here to help. Contact me by email and we can arrange to do an engagement if I need to assist you. I may well put together some form or model forms that you can use to send to your employees to request the documentation you need. So keep on the lookout for that. I don't have that at this moment. So here's a question. What would be your recommendation on deciding for early implementation? What I think you should do is if you have employees you think might qualify for this leave right now, I think what you want to do is contact them ASAP and ask them, do you think you qualify? And if so, you want to get something back from them, even if it's just an email back from them that says, I think I qualify, here's why. And also ask them to tell you how many hours they think they qualify for. In lieu of doing formal documentation, if you ask them that now, you can get the documentation later and you can correct if you're wrong. What I think you want to do is to get going on this as soon as you can, as soon as you are practically comfortable doing it, which means, depending on your period, potentially all the way back to the beginning of this week. And get what you can that allows you to reasonably take the credit. If it turns out, then when we come back a week later and we ask them for the documentation and get more detailed, we determine they weren't eligible for it, now you're at risk that you conclude they weren't eligible for it and you can't get the credit. So that's the risk you take. The plus side is you might get a credit. And if the situation resolves itself, then you might run out of time to use up the full credits that you otherwise might be entitled to. And so, so that's a judgment that each employer will need to make, but I certainly would consider early compliance because of the tax credits that you can get. Okay, with that, I'm going to end the webinar, and I thank you all for attending. And I apologize again for the weirdness of the way I did the presentation. I wasn't able to put it into presentation mode, or at least I wasn't able to. So thanks for attending.